My name is Attorney Joe Feeney. If anyone doesn't recognize me, I just want to, I do recognize some of the judges. Good to see you again. This case involves, if you read the brief, I'm sure you have, this case involves a case which I think has been a long time coming to this most honorable court. It involves, as you well know, search and seizure of my young client who sits the leftover.
Could you tell me, when did the seizure occur?
Well, I'll tell you, the seizure occurred, Judge, when the 4 very large police officers leaped from the unmarked vehicle at 6:40 p.m. on a dark night. It was black, and jumped out. I mean, they jumped out and leaped after my client.
Well, when they got out of the car, was your client in the same position he was in when the car drove up?
Yes, Judge.
I thought he had started to run.
So you're saying he did not start to run until they got out of the Crown Victoria car?
When those doors flew open, he knew enough, I would say, as reflex, or as Jack Linder would say, to call the wild. He knew enough to hit the road.
Not to quibble, but didn't the trial judge find that he started to run? He looked, he saw, started to run, and then they got out of the car? Isn't that what the judge found?
Well, if you look into the minutia of what the judge was writing, you could look at it from your standpoint, Your Honor, and you could look at it from my standpoint, which is that since I was there and I was cross-examining.
Aren't we as an appellate court bound by what the trial judge found?
The cases do say, we all know the cases are well, that unless there's a reason to believe that the trial judge factually made an error, they accept his factual findings. But let's look at this for a second. I'm glad you brought that up, Judge. What were the factual findings he found that was most important? Well, he didn't believe the police officers. He didn't believe a single word they said.
Well, he got to see them. He was watching their demeanor and making his assessments.
Correct.
We can't second guess those findings.
And what does that tell us about the police officers? 4 witnesses. The only 4 witnesses, other than my client, that were there that can testify about what happened that evening, we can't believe a word they said, according to the judge, whose factual finding, as you pointed out, our good Justice Farrell, as you pointed out, we have to accept his findings of fact, absent clear error. And so, you know, we're in a sticky wicket. We can't accept what they are saying on direct examination. And in the cross-examination, the judge can't believe what they're saying, and Judge Duggan wrote a very good decision. You very rarely see a 3-page decision, or in this case, it was 3.5 pages, so well written by a district court judge. I'm so glad he did. It was such a pleasure to see a judge write a decision instead of writing across the top page of your brief, you know, either allowed or dismissed. And we see that all the time, unfortunately. But the crux of the matter is that we are fortunate in this state to have something called the 14th Amendment. The good Lord has blessed us with this Article 14, I'm sorry, I didn't say, I said amendment, Article 14 of the Massachusetts Declaration of Rights. And anyone who's lived out of state, as I have, or overseas, as I have, wants to kiss the ground that Article 14 was scorched on as soon as you land back in Massachusetts. Because outside, we know the Fourth Amendment has been torn up and torn to pieces through 4 different presidential eras where they have changed judges and changed decisions to allow the police to do pretty much whatever they want when they see someone and want to search the person, stop the person. But in this state, we don't allow that. We give higher rights. Now, we go by the Mendenhall Hodari standard, and I'm sure you're all aware of that. I'm not here to give you a historical briefing on it, but Mendenhall is our standard. And on the Mendenhall,
why is there no transcript in this case?
Judge.
Why is there no transcript in this case?
There is a transcript, Judge. You didn't receive one?
I asked for it in the clerk's office. They said there was no motion to suppress transcript that's been filed in this case.
I know I brought one in, Judge. I did, and
So it exists.
it certainly does, Judge. I remember the day that I had to bring it in because it was a rather poor day weather-wise. I had to go and get it and bring it in and make copies of it. But I could make sure that you get one. I believe you should have one.
All right. Well, we may have to resolve.
Transcript is most important to me because you can see. I thought you had one. Sorry. I thought you would have had read all this already, and that we'd be starting.
We have the briefing. We just don't have the transcript of the motion to suppress hearing, to my knowledge.
We have the judge's decision below. We have the briefing, but no transcript.
Your Honors, I believe that transcript is pivotal in this case. So I would suggest that maybe we put a hold on this until you get the transcript.
No, that will not be necessary, Mr. Feeney. We will be able to get the transcript.
Mr. Feeney, can I
Okay, Judge, I appreciate that, Judge Marshall. It's very nice of you.
Can I ask you this? I mean, you would agree with me, I take it, that the police can follow someone that they see doing something suspicious, like running off. They can sort of follow him and find out where is he going, what's he doing, what's he up to. That's okay. That's not a seizure, right?
Well, let's break that down, Judge, if you don't mind. Can the police just follow anyone? Is that what you're saying? Okay. So, yeah, the police could follow someone, and if they're performing a dutiful surveillance of someone, that's their job, that's fine. Even if it's just something they're looking at because they just, maybe out of curiosity.
Yep. And you're saying that's not this case. There's something
not this case,
that this
Judge.
is, you can follow, I take it, and if the person's running fast, you could follow fast. But you're taking
Sure.
that, your sense here is the judge has concluded this wasn't following, this was a chase for purposes of stopping him.
Correct. And I think that you're making a good point, Judge, when you, factually, I think you're referring to one of our cases, the Stout case, and several other cases. It was the Stout case, and I believe, the Stout case, the Perry case, and many others, where the defendants actually picked up speed. Some were on bikes, some were running. But this is different altogether, Judge. Judge, over there, and I hope you didn't hear me threshing through my papers, Judge, but I have over there close to 70 cases. 63 of them are from my good brother that are submitted in his brief. And I don't know if you know what it's like to go through 63 cases several times.
I do.
I'm sure you do. And I noticed, I'm sorry, Judge, can I ask a question? Does this have a timer on it? Does it say?
Yeah.
Yes.
I don't see it.
It should be
Yeah.
facing you.
Excuse Mr. Feeney? Yeah.
Oh, sorry.
Oh, right there. I'm sorry. Thank you, Judge Marshall. I appreciate it. The actual case that we have, I think when I said it's been a long time coming, I truly meant that from the heart. This wasn't something to try to, I wasn't trying to use some smoke and mirrors game here. We have many cases where the police were called in, someone said, he has a gun. I believe that was the case you're referring to where they followed the
Mr. Feeney,
young man.
could you just confine your argument to this case, and let me ask you this question.
Judge.
Did your client testify?
No, Judge, he did not
Okay.
testify.
The judge in this case made a finding that the unmarked Crown Victoria with 4 adult men in it was usually recognized in the areas where the police patrolled as an unmarked police car. Who testified to that?
The police officer who drove did, Judge.
He said, we are usually, when we drive 4 adult men in an unmarked Crown Victoria, I don't know who usually recognizes it, but there was testimony to that effect?
Yes, so my
Okay.
recollection, Judge, was that the last person to testify was the actual driver. And the driver, what happened, Judge, was that in the facts, simply, Mr. Franklin was standing in between the property of his cousin and another foot on the sidewalk, talking to a friend. And when the car pulled up, it pulled up at such a short, quick, abrupt stop. And these large men got out at nighttime in plain clothes heading towards him that he just ran, the other man ran. Now, the other man who ran,
But the judge didn't make that finding. The judge said that the Victoria stopped, and immediately after it stopped, the defendant started running down the street away from the car. That's what the judge found.
and Judge, I'll tell you why my client ran, even though he wasn't.
Well, let's focus on what the judge found.
Sure.
The judge found that as soon as the car stopped, the defendant started running, right?
Yes, Judge.
Okay. And you've already told Judge Cordy that police can follow someone, and if they're doing that under surveillance, there's no problem, right? You made that concession.
With the exception that we're missing one important point, Judge. The cases, pretty much all the cases lately have said that we need to look at the totality of the circumstances. And this was not a simple case of someone just surveilling or following Mr. Franklin. No, not at all. Under the totality of the circumstances, this is a whole different case. This is a car coming at, I believe the testimony, which I don't want to get into, is that you said he ran after the car stopped. And
Well, that's what the judge found.
correct. And, Judge, unlike the other cases, Judge, the police have no reason to go into a hot pursuit after my client. Now, how do we know this hot
They
pursuit?
can follow him, right?
If you read the transcript, you see that there was I believe it says, headlong pursuit.
So he runs. Can they run, or do they have to just follow at a slow pace?
Well, if they're running after him at a high rate of speed, Judge, I say it's a hot pursuit, and I think anyone reasonably would believe that they're not free to leave, especially in this city.
Can we draw up the conclusion from the judge's factual findings that the defendant knew the police were chasing him?
Oh, yeah.
We
I'm
can.
sorry, I shouldn't say, oh, yes, I apologize. You know, I'm trying so hard to stop talking like my kids, and I'm trying to set an example. I'm sorry. Yes.
Okay.
Yes. I didn't even say, oh, yes.
So
yes.
the record, you would say the judge's findings would support the ultimate conclusion that he was aware that the police were chasing him?
Yes, absolutely. They were within arm's length of him at all times.
But that's not, there's nothing in the findings that would indicate that at all.
Well, actually, Judge, if you look in the findings, you'll see that the police offered, there was testimony that they saw and heard they saw a gun being thrown over a fence,
Yeah,
and they
but
heard
that-
the clicking of the gun hitting the pavement. And then they grabbed him. So they were pretty close.
I don't know where they started out.
They started out at the head of Harmon Street, which
I mean, I don't know how far the distance was when they
Oh,
started. Between the police and your client.
if you read the description in the factual findings, I believe you'll see that it was a driveway. And this particular driveway is a typical driveway. You know, typical driveways are usually like 6 feet in width. And so these two large men had him pretty well covered, and they just grabbed him and, you know, threw him down, and that was it. And that was based on them saying they just saw him throw the gun, heard the gun go bang over the hood. I mean, this was an immediate grasping, an immediate seizure of my client. So my client had no doubt with the clomp of these men, 200 pounds, 6 feet tall. And, you know, my client, 5 feet 6, 140, he knew they were coming after him. No doubt.
I take
no
it
doubt about
your sense is the transcript will make the sequencing clearer than perhaps the judge's findings?
I believe it will make it crystal, Judge.
Okay.
You know, and I don't have the memory of Socrates, but I do believe it will become crystal clear to you, Your Honors. And Your Honors, may I say this? I thought about this case for a long time. I've been waiting for a case like this for a long time, Your Honors, because I grew up in this city. I left for a while, came back, was overseas, came back, and I've seen injustices happen. And I want to see happen in my city that I love, what happened in other cities overseas. I've seen the fear in these kids' faces when they see these unmarked vehicles coming in. To tell you the truth, I get fear myself. I want to get away from them. I don't want to be anywhere near them. I just see
Mr.
it every
Feeney,
day.
please confine your comments to the record in this case.
Your Honor,
We
I'm
appreciate it.
sorry. You know, my time is coming up. I appreciate that, Judge. And I'm sorry for getting. I'm sorry. I'm sorry for the emotional part of my
Thank you, Mr.
No problem.
Feeney. Your
Thank
time is up.
argument. Thank you, Judge. And I'm sorry. Thank you, Your Honors. And it's good seeing the ones again that I'm familiar with. Hope to see you again in the near future. And have a great weekend, please.
Good morning, Mr. Zanini.
Good morning, may it please the Court, Madam Chief Justice, Justices. John Zanini on behalf of the Commonwealth. With me today is Assistant DA Christine Walsh, who handled the motion hearing, ADA Celio, who helped brief the case, and Officer Bloss is also in the courtroom today.
Could you just tell us if you are aware of a transcript?
I'm not aware of a transcript. The Commonwealth was the appellant. We took the appeal based solely on the judge's findings and rulings. We did not order a transcript. I've never seen a transcript.
Now, based on those findings, do you agree that there's a difference between pursuit for the purpose of surveillance versus pursuit for the purpose of stopping or tackling somebody?
I would agree, and we would probably know the difference when we get to the end point where the person is either tackled or not.
Well, but you
although-
may know it before. I mean, I assume that a halfback on a football field recognizes that that's not a pursuit for surveillance as opposed to a pursuit to tackle.
Sure, because of the
And would
circumstances.
would an individual not have the same, be able to understand that the police may be surveilling him versus chasing him with the intent to stop him?
Well, the police may be chasing a person with the intent to ask them a question, and that may be intrusive, but it may not be intrusive in a way that requires the application of the exclusionary rule. So if they're following a person at the same speed, or even if they're slightly accelerating in order to catch up to a person, as they do in a lot of the cases in a cruiser, coming up on someone on a bike or someone who's running and saying, hey, can we talk to you? Are they intruding on his right to be let alone? Sure, he has a sense of that.
So are you saying then that we can't determine that there's a seizure when a police officer is chasing a person until the police officer catches up to the person?
No, I think that there's the word seizure, I think we might want to set aside for 1 second. And we might want to think about, people have a general right to be let alone, but the police also have a right to follow people and surveil people. And you can intrude on someone's sense of privacy or their sense that they have a right to be let alone without necessarily getting into a situation where the exclusionary rule is.
Right, I understand that. I
gonna
guess
apply or
my
be
concern
revoked.
is, from Judge Dugan's findings,
Yes.
how can we know whether this is a pursuit to surveil or a pursuit to stop?
Right.
I
Well,
couldn't
I don't-
find
I don't-
anything in his
I don't-
findings which
it-
helped me
okay.
even to know whether or not the
No.
defendant was aware that he was being chased.
Correct. And so I would say this, if the subjective intention of the police officer, pursuit to surveil or pursuit to seize, is irrelevant.
Right.
It's a reasonable person's understanding of it, but
there's-
how do we
there's a
even
gap.
understand that from that?
And the reasonable person has to be aware that, for instance, that they're being followed and the police have exhibited objective indicia of their intent. If the person is unaware, then there's simply no pursuit at all.
Well, there's no seizure. I agree with that, but so let's assume for a moment that the record is sufficient for us to find, and let's assume we find that the judge essentially found that the defendant was aware that he was being pursued in this case. Is that enough? Does that
No.
mean there's a seizure?
No. I mean, I think it's clear, for instance, Grandison is quite instructive on this. Mr. Grandison was walking down the street when a police car drove up. The police officers looked at him. He changed direction. They had their headlights on him. He changed direction again. They kept following him. He went down an alley. They put their alley lights on him. So he was clearly aware the entire time the police were following him and wanted to keep an eye on him, but he was never seized for constitutional purpose.
So if the police officers had yelled "stop," that would be enough.
Absolutely.
In the course of the chase, hey, you stop.
That-
That would do it.
That would clearly be what we would consider a seizure for constitutional purpose.
I have two factual questions. Can we tell from the findings exactly when the defendant began running?
Yeah. Immediately after the car stopped.
Right, so on
Before
record,
they got out of the car. That's
yes,
what-
on record appendix 16.
Okay, so before they got out of the car. Now, also the appeals court, it seemed to me they didn't mention the eye contact by the defendant with the police officer, and you mentioned that.
Well, the trial judge discredited the police testimony on that point, correct?
Was it on the eye contact, or was it on,
Yes.
I thought it was on other points that he described.
think it was
Yeah.
the
Oh,
eye
he said he didn't believe that
The
there...
court
he-
does not
yes.
credit any of the police witness testimony that Franklin looked surprised or nervous given the police car's movement.
Right, but he didn't say anything about the eye contact, so that's why I'm
Right, I
wondering
would-
about that fact.
Right, there's no eye contact that I see now, looking at the judge's factual
Right,
findings.
I didn't see it.
I don't see eye contact.
Yeah, and I don't see it mentioned in the appeals court decision, but you
But I
make a point
suppose
of
you
it.
can infer that because he says it's an extremely short time. The police had to observe Franklin before he took off, and the three of them jumped out of the car in pursuit of Franklin, correct? I mean, I
That-
took that to say maybe not eye contact, you know, if you're going to
Right.
focus.
I mean, the reason the police stop is because Mr. Franklin is the one who stops talking and starts looking around, so that's why they stop. That-
Is-
Because of his reaction to their presence. They don't cause him to do anything. But I don't see eye contact.
No,
In the findings.
in addition to a police officer saying, "Stop," or "Come here," if a police officer is in a car and turns on the overhead, you know, the blue lights, blue and white, blue and red, whatever they are, that's an indication, that's an expression of authority that indicates stop, I take it.
Right.
What are some of the circumstances where we have said that a stop has occurred absent some of those things? For instance, if a defendant has a warrant outstanding for him and he flees and the police walk after him, or pursue him, and they don't say anything about stopping, is a defendant's knowledge that there is a warrant outstanding for him sufficient to create a seizure?
I don't believe it would be. I don't know of any case that says that, and I think there are warrants issued
Okay.
pretty much daily, especially in the district courts, default warrants when people don't appear, and I don't think that the people walking around the streets are thereby insulated from sort of.
What about the nature of a pursuit? If it's, you know, is in contrast to running on a sidewalk, if you're pursuing somebody through the woods, trees, bushes, is that some indication that 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 the police have effectuated a seizure?
I don't think it is. For instance, in the Battle case, which is in 365 Mass, which is pre-Hodari, that's a Mendenhall case, the police see a couple of individuals on the stoop of an apartment building. Those guys run into the common hallway of the building. The police get out of their cruiser and run in behind them. And the court said, well, that's not a seizure. They're still in a public place, and the police have the right and the duty to keep an eye on them. So they go in behind them, and there's no Fourth Amendment seizure there.
And then there's a
pre-Hodari.
case about a bathroom also, right? The police come into the public bathroom.
Oh, I don't think I cited that one, but right, there's a case where they go into the bathroom and there's drugs in the urinal, and they said, well, that's not a seizure. I mean, even though he's gone into a semi-private space, the police have a right to walk into that space. So I don't think if somebody flees through the woods, or if somebody runs across the ninth hole at the fairway at the golf course, and you run across behind them, that doesn't mean that you're seized. I mean, I would concede there's a sense of intrusiveness to what the police are doing, but the intrusion on somebody's absolute right to be let alone does not rise to the level of a seizure where you apply the exclusionary rule.
Now, here, the judge did not make findings about whether the police said stop or made any communication with the defendant, correct?
There is no finding that any officer said anything to the defendant.
Isn't that a very important factor? If they did say stop, then perhaps there's a seizure.
Perhaps.
If they said nothing, perhaps
Right.
they're
The facts
just
as
surveilling.
the facts as they exist, there was no command ever by any police officer to this defendant. They never said stop in the name of the law. They never said stop.
So from that, you then argue, well, the defendant was not aware that he was being followed or chased, and therefore there was no seizure.
I think you can do that as the motive analysis. I think you can also say he was aware that he was being followed.
Well, why was he running if he wasn't aware that if he had just been talking to somebody, why was he suddenly running? I mean, isn't it the reasonable
Because he's got a
inference?
guilty conscience and he's carrying a gun.
But then he's running from the police. Then the reasonable inference is he
he's
is
running from the
and that he
police.
knows that they're.
Well, he probably thought, they're behind me. Whether or not he took Satchel Page's advice and didn't look back, he probably thought, sure, they're behind me, they're gaining on me. But that doesn't mean
So
that
then
they
he was.
seized him.
So you can see that he's aware that they're running after him.
I don't, because there's no.
You just said.
There's no. I said, you can go that route if you want to. You can draw that inference, I suppose. But if somebody wants to get on the stand and testify and say, I knew they were behind me, they can do that at a suppression hearing. And if they don't want to do that, then the judge is left with a question about their subjective state of mind.
But did the judge make a finding on that subject?
No,
No.
he made no finding that this individual was aware, and I
Right.
don't think that's controlling. You can be aware that the police are following you, like Mr. Grandison with a spotlight on him, and not be in a situation where the exclusionary rule applies.
And you're saying that on these facts, there is no basis to order suppression?
Absolutely. On these facts, all they did was, when you look at Article 14 and think about reasonableness, everything the police did here was proportional to what the defendant did. It was the defendant who chose, when he saw the police car, to break away and run.
And when do you say the seizure occurred?
When they grabbed him on the fence after he tossed the gun.
Do you have any authority anywhere to support your new, to me anyway, new concept that it isn't a seizure, but it is an intrusion on his privacy, but it's only a little?
Well, I think all of the cases sort of indicate, especially Grandison, where you put a spotlight on a man.
It's implicit in them. It's implicit
Sure,
in
it's
them.
implicit. And I think Stout, actually I would cite Stout, 422 Mass 782 is the case at page 789, where the standard is really set out. What this court said was they talked about not just an infringement on someone's liberty, but the court said that the person has to be aware that there's a police officer's inquiry, which is the functional equivalent of a seizure, in the sense that the person being pursued is plainly the object of the official assertion of authority, which does not intend to be denied, and which infringes considerably on the person's freedom of action. So I think you're talking not mere intrusiveness, not mere following, not mere pursuit, but you've got to infringe considerably on their freedom of action, which is why subsequently the court has talked about, did you try to block or impede their movement? Did you try to control their direction? Did you try to control their speed? Or did you merely follow them or pursue them at the same pace at which they were going, whether they were on a bike or on foot or in a car, and you were in a car?
The difficulty I have with the Grandison case and these facts, Mr. Zanini, as opposed to the Stout facts, is that the pursuit cases really foreclose a likelihood that somebody is going to be blocked, because the very nature of pursuit is that they are moving away from wherever the blockage is. I mean, so that so Grandison is not very helpful.
Well, but if someone's on a bike, like they were in Sykes or Stout or Tebow, I mean, you can cut them off if you're in a cruiser, unless they go up on the sidewalk or do something like that. So you're not really foreclosed from trying to impede their movement or stop their movement or control their speed or direction, especially if you're in a cruiser.
In Stout, we said that a person can be seized for purposes of Article 14 when a police officer initiates pursuit with the obvious intent of requiring the person to submit to questioning. If the judge in this case had found, or had stated, rather, that I infer that from the nature of this pursuit, the officers had the obvious intent of requiring him to submit to questioning, that would have been that would have been supported by this record, by these facts that were found.
Well, I think that's one inference you can draw. The other inference...
No, I'm asking you, would that have been would, if a judge had stated, had expressly stated that I infer from these facts, which are all the facts that we have, that the officers intended to seize the defendant, would that support a suppression order?
Sure, that finding would support it, but I don't think that it requires a suppression order, because even if they, sorry, Justice.
No. I was going to say the obvious, it has to be obvious to the person being pursued. It's not a question of police intent. It's whether the intent was obvious to the person being pursued, because a reasonable person having those facts in mind wouldn't feel free to leave, even though they were.
First, it's got to be obvious to that person. And second, the mere fact that even if he knows that doesn't necessarily mean that it's such a significant impingement on their freedom that it was, I would say, so disproportional to their conduct that it would be unreasonable and therefore require an exclusionary rule. You can act reasonably under Article 14, and reasonable means you act in proportion to the facts, all of the facts you know. And as long as your conduct is proportional and reasonable, there is no reason to apply an exclusionary rule.
Well,
When do you say here that there was reasonable suspicion?
I think as soon as he started running, there was
Do
reasonable
you think that the
suspicion.
flight alone is sufficient?
Excuse me?
You think flight alone is sufficient
I
to
don't
constitute
think there's
reasonable
flight
suspicion?
alone here.
So what else is there?
yeah, what else you have?
Well, I think you have an area, as the judge found, which is a hot spot for guns and drugs, which is not to
Okay.
be minimized.
All right.
There are areas in the city that,
Anything else?
yes, you have an individual who's engaged in conversation with his companion, who upon sight of a vehicle, which the judge says is recognized as a police vehicle, breaks off his conversation, looks around, obviously for a way out, and then starts running as fast as he can. His companion, if you read the judge's finding, stands there because Sergeant Joyce gets out of the car and approaches him.
So
So-
you really have, you have two alternative arguments. You say he was actually seized when he was tackled, but if we don't buy that, if we accept the judge's conclusion that he was seized when the police officers got out of the cruiser, not cruiser, the Crown Vic, that's okay because there was reasonable suspicion at that time.
Absolutely. And I have sort of the sub-argument that what they did was entirely reasonable and proportional, even if you don't think there's reasonable suspicion of a crime, and therefore exclusion is not required. And I have the last and probably least attractive argument to this court,
Well, that
which
one's
is
not
that
so
the
attractive
exclusionary
either,
rule
but-
shouldn't apply because he'll be prosecuted in federal court under 18 U.S.C. 922G, which I understand the court might say, well, the federal government can do what they will, but we still have our own exclusion.
Now, is there any case where we have found that flight plus being in a high crime area is sufficient to constitute reasonable suspicion?
Not yet.
Thank you, Mr. Zanini.
Thank you.